and gentlemen, you've been here on the case of State v. Matthew and Willard Hernandez. Again, it's not State v. DFCS, it's not State v. CHOA doctors, it's State v. Matthew Hernandez and Willard Hernandez. And they've been charged with 2 counts of aggravated family violence and 2 counts of cruelty to children in the first degree. Now, before I go into the evidence in part 2 of my closing, I would like to talk about the law that the judge will read to you. The state has a burden of proving our case beyond a reasonable doubt. Reasonable doubt is often defined as what it's not. It's not beyond all doubt. It's not to a mathematical certainty. It's not a vague and arbitrary doubt. It's a doubt that is reasonable. It's the doubt of a fair-minded, impartial juror honestly seeking the truth. Members of the jury, your duty is to seek the truth, not doubt. And it's also a doubt based on common sense and reason. Do not leave your common sense at the door as you go out and deliberate. You are allowed to use your common sense in this case. Now let me give you an example of what is considered reasonable. If a person were to walk in here wearing a raincoat and that raincoat is wet, is it reasonable to believe that the person jumped into Lake Lanier and walked into the courtroom? Or is it reasonable to believe that it was raining outside? Now, it's possible that that person jumped into Lake Lanier and came into the courtroom, but is that reasonable? There's a difference between what's possible and what's reasonable, and the state's burden is to show proof beyond a reasonable doubt. And you'll hear one of the charges being crime charged in 2 ways, and this is basically legalese. If you see and, that means or, and if you see or, it means and. Count 1, the defendants have been charged with aggravated battery. In order to prove our case beyond a reasonable doubt as to aggravated battery, the state has to show that they maliciously caused bodily harm to Emma by seriously disfiguring her body or a member thereof. In count 1, that is ribs. And malice is not ill will or hatred. It is the actual intent to cause bodily harm without justification or excuse. It's the wanton and willful doing of an act with an awareness of a plain and strong likelihood that such particular harm may result. An intention can be shown by the circumstances connected with the offense. Ladies and gentlemen, when a 3-month-old who can't walk, who can't crawl, who can't roll over, has 3 fractured ribs, highly specific for child abuse, when there's enough force being applied to the bendy bones of an infant, to the extent that it causes fractures, that is malice. It caused bodily harm to Emma, and it seriously disfigured her ribs. And how do we know that? Because serious disfigurement can also be visible through such means as an X-ray. And we saw that in her X-rays. You see, on July 31st, 2023, after her ribs have remodeled, that is what it should look like. And on June 6, 2023, it is clearly fractured. You can see it. That is serious disfigurement. It is not normal. It is not the normal ribs of what a 3-month-old baby's ribs should look like. Count 3 aggravated battery is for maliciously causing bodily harm to Emma by rendering a member of her body useless, and that being her leg and foot. Again, rendered useless. Malice is the same definition. It does not have to be ill will or hatred. It's the actual intent to cause bodily harm without justification or excuse. And it's the wanton and willful doing of an act where there's a plain and strong likelihood that such a particular harm may result. Now, what does rendered useless mean? It does not have to be permanently useless. Even the temporary reduced use of a bodily member may be sufficient to be rendered useless. And in this case, Missouri, we know her leg and foot were rendered useless because the defendant, Willard Hernandez, noticed that Emma's leg was not moving properly. She noticed that her right leg was not moving as much as her left. We know it was rendered useless because Dr. Chunduri noticed that Emma was not moving her right leg as much as her left. We know it was rendered useless because Dr. Krieger noticed that Emma was not moving her right leg as much as her left. That child was in pain. It was rendered useless. Count 2, cruelty to children in the first degree. The state has to show that the defendants maliciously caused cruel and excessive pain, physical pain, in this case to her ribs, to a child under age 18. I don't think there's any dispute that Emma was under the age of 18. So I'm going to touch on what malice is again, and cruel and excessive physical pain. Again, malice is not ill will or hatred. It's the intent to cause pain without justification or excuse. Willfully doing an act while aware of a strong likelihood that pain may result. And you heard evidence that infant bones bend. They don't fracture easily. When infant rib bones fracture, that is considerable amount of force. And that's why it's considered highly specific for child abuse. Because there's no reason that a child 3 months of age should have rib fractures. And you heard from Dr. Mulholland Ray and Dr. Mesner, this is caused by a compressive force. You heard from Dr. Mesner that this would have been painful for Emma, and that whoever was in that room with Emma when this happened would have known that she was in pain. That's cruelty in the first. The state's also charged the defendants with count 4, cruelty to children in the first degree, for maliciously causing cruel and excessive physical pain to her leg and foot to a child under age 18. Again, Emma, 3 months old, under the age of 18, so covering malice. Again, it's not ill will or hatred, it's the intent to cause pain without justification or excuse. Willfully doing an act while aware of a strong likelihood that pain may result. And members of the jury, you heard that Emma was having difficulty moving her right leg. That's cruel and excessive physical pain. Classic metaphyseal lesions, highly specific for child abuse, caused by yanking or twisting. And the foot fracture was caused by trauma, such as a squeezing. And we heard testimony both from Dr. Lynham and from Dr. Mulholland Ray that it's highly unusual for a child Emma's age to have such foot fracture, especially when they can't walk, when she can't walk. There's no reason a child 3 months of age who can't walk, who can't crawl, who can't roll over, should have these leg and foot fractures. You're also going to be instructed on party to a crime, and that's that every party to a crime may be charged. Let me go back. A person can be charged and convicted for directly committing the crime, but they can also be charged and convicted for intentionally helping in the commission of the crime. And that's what party to a crime is. You can find that one parent hurt Emma and that the other one didn't do anything about the fracture over a period of time. That for every diaper change, for every burping, that parent ignored the pain of that child. That they intentionally helped commit that offense. Because members of the jury, if you'll recall the evidence, these fractures didn't just happen once. They were at different stages of healing, meaning that it happened more than one time. They both knew what was going on in that home. Emma just couldn't talk about it because she was nonverbal. Both parents played a role in this, and they both did this to Emma. You'll also hear a charge on evidence, direct and circumstantial. At the end, it's a long charge, but at the end of it, it basically means evidence is evidence, whether it be direct or circumstantial, and that you can hold weight however you feel it appropriate. Another charge that you'll hear is on the credibility of witnesses. And in considering the credibility of witnesses, you're to consider the manner in which they testify, their interest or lack of interest in the case, their means and opportunity for knowing the facts about which they testify, the probability or improbability of their testimony, the occurrences about which they testify, their personal credibility as you observe it, the levels of details, the lack of any motive to lie, consistency of their statements, and any behavioral indicators. And this credibility also applies to expert witnesses as well. There were a lot of experts.
And Your Honor, I would object at this time. We were prevented from going into behavioral indicators with the witnesses that we had available to testify about precisely that issue to the jury. I don't think it would be proper for the state to be able to now say that that evidence would be relevant.
I'm talking about how they look like on the stand.
I'm in agreement. Overruled.
Thank you. This applies to expert witnesses as well. There were a lot of experts in this case. We know not every expert was of equal caliber. So you must decide for yourself whether or not to rely on their opinion. Now, in the second part of my closing, I'll be back before you to go over the evidence. And at that time, I'll ask that you find the defendants guilty of all charges. Thank you.
All right, thank you, Ms. Hughes. Ms. Bernard.
All right. Good morning, ladies and gentlemen. It feels like a long time ago that I came before you for jury selection, and we talked about all the factors of this case from the perspective of how do we pick the best jury? How do we pick the people who are going to be able to sit here for 2 weeks, these incredibly important 2 weeks, listen to all this evidence, some of it difficult, and come to the right conclusion? But we're so grateful because y'all have stuck with us this whole 2 weeks. We haven't lost anybody. We haven't lost anybody's attention. Y'all care about doing the right thing in this case. It's evident. And so you already know. You've already heard all of the evidence in this case. And so you already know that the state didn't prove this case beyond a reasonable doubt. Because nothing the lawyers say is evidence. All we can do is give our perspective in closing arguments and try to wrap up some things from the past 2 weeks that might provide you some assistance as you go back in that jury room and deliberate. And so I've got half an hour to talk to you all about that, and I'll try to hit the points that I think are going to be most important. But y'all are the ones who have been hearing the evidence. Y'all are the ones who know if evidence has been brought before you to prove what the state has said. And let's start off with the state saying this is the state versus Matthew and Willard Hernandez, not DFCS, not CHOA. I agree. That is the case. It is the state versus the Hernandez family. However, it is not CHOA versus the Hernandez family. At no point has Forsyth County delegated law enforcement authority to CHOA. And that's important because generally in a criminal case, the way it works is that a law enforcement officer will come and testify about what they did in an investigation of what was going on, how they determined the facts that they swore to a judge in a warrant were true, so that a prosecution like this could begin. But who did the investigation in this case? Who did the investigation and was willing to sit up here under oath and look at all of you in the eye and say, yes, I am confident that these people abused their child? No one. The state had not a single witness who could stand up here and say, or sit up here in the witness stand and say, I have reviewed this whole case. I know everything about Emma Hernandez's medical records. I know everything about the circumstances of her family. I know everything about her health conditions as it persisted throughout the multiple foster homes. I know everything about all of the medical appointments that her parents took her to. I know everything about all of that. And yes, ladies and gentlemen, you can be confident that one or both of these people committed heinous acts against their child. No one was willing to do that. The state had no one who could come up here and swear to that. The closest thing they had was some doctors from CHOA. The first one who made his decision in under 2 hours. He looked at some x-rays, didn't even talk to the other doctors who had already been treating Emma Hernandez after her parents brought her in for help finding out what was going on with her and her health. One doctor came in, interrupted the orthopedic consult that was already in process and that Emma was already being treated for, and had to come in with his, well, we don't know, was it an impression, was it a diagnosis? That didn't seem very important to him on the stand, but he decided that it was non-accidental trauma. And once you have a doctor from CHOA putting that in the record, it's amazing how all the other doctors then find that same thing. Well, not all the other doctors, because the state had a lot of other doctors that they could have brought before you who treated Emma Hernandez. And you have to ask yourself why they chose not to bring any of those doctors before you. In a fracture case, they don't have a single orthopedic resident or doctor or anyone and who's an expert in the field of bone fractures to come and talk to you about this. They have to rely on a child abuse pediatrician and one pediatric radiologist who wasn't even involved in the original reading and didn't even write her own report. Ladies and gentlemen, there's something wrong with Emma Hernandez. And one of those things is that there are doctors in that case who forgot their oath to first do no harm. And instead, when they were the hammer of a child abuse pediatrician, everything looked like a nail for them to hammer in. These are not the medical records of a perfectly healthy child. A perfectly healthy child doesn't have to be admitted to CHOA for multiple days, doesn't have to come back barely a month later and stay for another week and have to have consults with multiple departments at Children's Hospital. There are doctors who knew that something was going on with Emma that needed to be thoroughly investigated, but the state didn't bring any of those doctors before you today, even though they appear in the medical records and provided their impressions of Emma Hernandez's case. So none of these people, even the child abuse pediatrician, were willing to come to you and say, I am confident that these people abused their child. So no one will take responsibility for looking at all of those facts and coming to that conclusion that they are asking you to find beyond a reasonable doubt. If there's no witness from the state who even has the facts and can believe this beyond a reasonable doubt, how on earth did they expect y'all to? It's really, there's a lot of things that have been unusual about this case. In terms of, I think some of y'all have had the experience of serving on juries before, but there have been a lot of things that have been unusual. The state also told you that this wasn't DFCS versus the Hernandez family. Well, it was for a long time until those people did their investigations and all came in to testify for the Hernandezes. Yep,
Your Honor, she's going into the DFCS case.
That's correct. She specifically said that this case was not DFCS versus the Hernandezes. She opened the door to the discussion.
You could open the door, you can go into what the evidence was allowed in by the court. Okay?
So ladies and gentlemen, the Georgia Constitution provides that y'all are the judges of the law and the facts. You are the ultimate authority in this courtroom and this courthouse. I told you at the beginning, that's why everybody, well, except for the DA's office, is standing up when y'all enter and leave the room, because you are the ones whose opinion on the law and the facts matters. And so you might also have a disagreement with what the prosecutor and the judge consider relevant in this case. Because the only investigation that was ever done into the Hernandezes was by these individuals whose job it was to look after the best interest of the child. People who had extensive training from DFCS itself in early childhood education, in complex trauma, in elementary education, in school counseling, in child development. All of these people who worked on this case all came in to testify for the Hernandez family. I'm not even sure if any of us can really appreciate how unprecedented that is in a case like this. Because honestly, most people, if you took their baby away and then went back to try to look for something that they had ever done wrong in their life that could be used against them, honestly, with most people, you would probably find something. But the state couldn't find a single thing on the Hernandezes. After they opened their lives to the state and every single one of its agents, after they opened their lives to that for 2 years, the state still couldn't find anything bad to say about that couple right there. That sweet couple who met up in New York and moved down to Georgia because you know what? They didn't have a ton of money. And it is a cheaper cost of living down here. And it was nice to be close to family. And building a beautiful life here in Forsyth County. And so you see how their reaction was when they experienced this accusation. They reacted exactly as normal, healthy, concerned parents would. All they cared about was making sure that their girls got the care and attention and love that they needed. That was what they were worried about. They spoke to every single person who asked them. They got dragged out of the room in the middle of the night. Oh, this is to talk about breastfeeding. Actually, no, it's to ask you a bunch of questions so we can try to prove you guilty. Even under those circumstances, they could not find one single thing to bring before you as evidence that these people were evil and wicked enough to intentionally inflict harm on their tiny, beautiful 3-month-old baby, Emma Hernandez. And so, ladies and gentlemen, you have the opportunity to imagine when you hear the judge's charge and hear its requirement that in order for the state to prove the guilt of these people beyond a reasonable doubt, that they must exclude all reasonable theories of innocence. That's going to be up to you to decide. But what I put to you is that they haven't even come close. They haven't even provided a reasonable theory of what they are accusing these people of doing. At no point has anyone come to you and been able to say, I think this happened. I think this happened on this date. Here's how it happened. Here's the evidence that shows why it happened. All they've got are the x-rays. And it's funny because even in the state's opening to their closing argument, it's like they realized how much they messed up about the bruises. They realized how much they messed up because these doctors that were seeing Emma in July somehow got information that she was still in the custody of, or that her parents still had access to her, when that wasn't the case. Loving family members had taken Emma and Arya into their home because nobody was there to make excuses for a family member. You know, anybody hears these accusations, they're immediately going to have the same reaction, certainly that I had when I looked at the reports in this case. What I think y'all had when you first heard the testimony of the doctors and the accusations, which is, oh my gosh, how could anyone even think about hurting a tiny, helpless child? But they opened their lives. They made every piece of information available to the state, to DFCS, to CHOA, to law enforcement, over and over and over again. Their family members did that too. And so that's why the state has just abandoned this bruising idea. Their only evidence of it was what the parents had brought to them themselves. Because they, like any normal parents, wanted to figure out what was going on with their daughter, Emma. She had had more health problems than Arya. And that's not surprising, because what we've learned, again, looking at these medical records, not that of a healthy child, we have learned what was probably going on with Emma. And that was, number one, that she had a vitamin D deficiency. She was exclusively breastfed. Her mom was anemic during pregnancy. It was a little bit of an older pregnancy. She was taking a prenatal vitamin that apparently didn't have enough vitamin D in it. And so Emma, when she was 11 weeks old, had a vitamin D level that was well below what is considered adequate by CHOA's own records. And that's where, you know, the judge will tell you that if you can resolve a case with that, while believing that everyone is telling the truth, that you should. But in this case, we know that somebody's not. And sadly, we've got to point the finger at people like Dr. Stephen Messner. And you can see that from the very beginning of his testimony, when I asked him about Emma's genetic abnormalities. And do you remember I kind of laughed? Like, oh, this is funny, you know, oh, look at this defense lawyer trying to find some excuse to, you know, excuse for these child abuser clients of hers. Because that's what he thinks. That's his approach. And if that's how he's willing to treat lawyers in court, just imagine how he's treating parents that he has designated as child abusers and that everybody else is listening to his judgment of them. Just imagine the experience that these people had trying to take their child to doctors to figure out what was going on and having every single person treat them like dirt because people from DFCS, people that the state didn't bring before you, were in those appointments saying, yeah, they abused their baby. There's no point in us being here. They're just looking for excuses so that they can get out of trouble for abusing their baby. And so that's why I'm in the position of having to say, I don't think Dr. Messner was being honest with y'all. Because when he laughed about Emma's genetic testing that his friend Dr. Wilcox did over at Emory, he told you none of her variants were pathogenic. Ladies and gentlemen, that is false. And as the person who was most responsible for this diagnosis of non-accidental trauma on Emma Hernandez, that's a big deal. It means you shouldn't trust him when he says that her labs were within normal limits, because of course they weren't. And then when we ask him about it on the stand, oh, well, here's a reason why that doesn't matter. Oh, why didn't you just say that from the beginning? You know, that she had an abnormal lab, but I looked at it and I decided not to be concerned for XYZ reason. That's what a real doctor would do. That's what a doctor who was following his oath and who cared about the safety and health of Emma Hernandez would have done. But what did Dr. Messner tell you? That he was never involved in Emma's case again after the diagnosis that he made on June 7th. He wasn't involved when she came back on June 23rd to have another skeletal survey and to receive a pelvic exam from another child abuse pediatrician. He wasn't involved when she came back at the beginning of July and was ripped away from her loving aunt and uncle because they were then accused of child abuse, because they were honest about the same manifestations of health concerns that had come up. And he wasn't involved when she was brought back yet again at the end of July for further treatment. He wasn't involved when she was brought back in August. He wasn't involved when she was brought back in December. Did he care about Emma Hernandez? Ladies and gentlemen, I think the evidence is clear. He does not. That for all of these multidisciplinary child abuse conferences that these doctors at CHOA are apparently participating in, not making any notes or recalling anything specific that might help the people who are supposed to be investigating what happened. No, they can't remember any of that. It's just rely on that diagnosis. He said it, ladies and gentlemen. He said it on June 7th, and so everybody else just needs to shut up and get in line. And that's what's been going on for the past 2 years, and it's been unimaginably hard for these people. You heard about the separation that they have endured, not only from their children, but from each other. 9 months where they couldn't even talk to each other or live in the same home. But you know what? They did it. They did it. They followed every order. They followed every rule. They followed every instruction. They took every visitation opportunity. They continued to do everything they could to be good parents under these circumstances because they had faith that the truth would finally come out. And that's what y'all are here for. So when Dr. Messner laughed about those genetic abnormalities, you have been able to see the evidence of what was actually going on, which is that Emma Hernandez had 2 genetic variants on her COL12A1 gene, which is a gene that produces collagen. And we got to talk to Dr. Lynham about it just this morning. She had to grudgingly admit that yes, bones are made up of a net of collagen that then mineralization comes on top of. So it's not like you just look at one x-ray and you can say, oh, these bones are perfectly healthy. The only way they ever could have fractured in any circumstance is if someone assaulted and attacked this child with malice. No. There are so many factors that go into that. You heard from Dr. Benson, a man who has spent his life looking at bones and putting people back together after they have experienced trauma. And he told you about the number of enzymes and proteins and cells and communications and so many things that that as a layperson, I'm just trying to keep up. But there's so many things that go into the way that Emma Hernandez's tiny bones were being built while she was in her mother's womb. And those things were affected by the variants she had on the COL12A1 gene. You've heard the medical evidence about that. You heard Dr. Wilcox on the stand when, again, I'm not a scientist, I'm just a lawyer who is reading all of this stuff and talking to the experts and trying to learn what's going on and saying, well, if she has two variants, from one from each parent, so you wouldn't see the same thing in the parents, but two of them together could have an impact. And well, we have this study that shows when you knock out the collagen 12 gene in mice, it makes their bones thin and brittle. And oh wait, she's got another variant on SLC34A1, which is a sodium phosphate co-transporter. And that's right, phosphate and phosphorus are critical parts of bone mineralization. And Dr. Wilcox shouted, "Prove it," at me. I mean, I'm not a 30-year geneticist like he is, but I will say he's the one who needs to prove it. The state is the one who needs to prove it because they need to be able to exclude all reasonable theories of innocence. And just those genetic results alone are a reasonable theory of innocence based on what we have all learned about the way bones are built and created. Add that vitamin D deficiency on top, and that's why you have somebody with Dr. Benson's experience coming in pro bono to analyze this case and tell you, of course, this is a situation where the strongest compressive force of the uterine contractions, because remember what we learned, she was induced. She was given the medication that forces contractions. And so that's the compressive force that her bones underwent. And maybe if she hadn't had those genetic variants, if she hadn't had that vitamin D deficiency, you wouldn't have seen the tiny little rib fractures. Maybe. Maybe the fact that obviously anything that happened to her leg probably was not birth related because there are some different signs in the way things heal that you heard from Dr. Hutchison, that these classic metaphyseal lesions, that's something that can happen later in a very minor way. So that might not be birth related. That might have come from sitting in a car seat wrong. That might have come from someone normally changing a diaper. It might have come from a whole host of things when a child has more fragile bones because of her genetic makeup and because of her specific vitamin D deficiency and because of her gut absorption issues. Because that's another thing, ladies and gentlemen, that, to hear these doctors sit up there and say, well, she never broke again. She never had any of these marks again. Nothing was ever wrong with her again. As soon as we took her away from her loving family and stopped her from getting breastfed by her mother and loved on by her family every day, she was fine. That is another lie, ladies and gentlemen, and it's a particularly ugly one when you heard what you heard about Emma Hernandez's actual condition. You heard from the daycare provider, the director of the daycare, that this was absolutely not normal. Emma was coming with discoloration on a regular basis. She was having vomiting on a regular basis. They were deeply worried about her. You heard from foster parents who had the same experience. You heard from foster parents who were taking her to the doctor over and over and over again. You heard from all of these people who verified that Emma Hernandez absolutely had ongoing health concerns. But you know who you didn't hear it from? the CHOA doctors who absolutely should have known. They should have made it their responsibility on any of those 24 multidisciplinary conferences on child abuse where they were discussing 5 to 6 children each month. You know what? This is my ask, and it might be crazy, but just throw Emma Hernandez on one of those. Just talk about her once. Maybe go talk to Dr. And I'm probably pronouncing it wrong, Nowaka, and Dr. Olszewski. Go talk to the actual orthopedist. Go talk to the folks in the nutrition department that you consulted. Go talk to the folks in the dermatology department. Go talk to the GI folks. Go talk to the bleeding folks. Because you did see multiple clotting studies have to be done. You did hear evidence that she had unusual bleeding because what happened right in the presence of the licensed credentialed supervisors, they had never seen a child have a tiny nick that wouldn't stop bleeding for 30 minutes and had to go to urgent care. The evidence is crystal clear. Emma Hernandez had ongoing health concerns. That is what brought her parents to bring her to the pediatrician after they had continued to bring her whole life for her well baby visits, her vaccinations, which, it's kind of a side issue, but they gave her that whole round of vaccinations again, basically barely 4 weeks later at CHOA, which is probably not great for a baby to get Hep B and all of that stuff all over again just because your system doesn't pull it up. Because that was weird how often we heard from the doctors, like, what shows in the medical records isn't the truth. Dr. Wilcox says, oh, abnormal genetic testing, I just have to put that in there for the billing. Dr. Chanduri says abnormal weight loss, oh, just got to put that in there for the billing. It honestly kind of reminds me of what you heard from the state in their closing argument, where they said, it's just legalese, and means or means and. No. Ladies and gentlemen, these are incredibly serious charges. In my view, they're more serious than murder charges. Because an adult, people can get in fights. But there is absolutely nothing that would ever in a million years justify anyone doing anything even remotely like what is alleged to have been done to Emma Hernandez by one or both of her parents. There's absolutely nothing that would ever justify it. And it wasn't done. Nobody committed these horrible assaults that the state alleges happened. And we know that because nobody was willing to come and swear that they had investigated and knew that it had. So you'll get to hear from Mr. Wasley, who will be speaking about things from the perspective of Mrs. Hernandez. And you'll get to hear more about some of the details on those lab reports. But I saw you taking notes. You guys have all this information yourself. You know what's going on in this case. And that is that when the state says things like highly specific for child abuse, but then when we ask their witnesses about it on the stand, they can't actually say what that means. Or when I dare to ask one of their experts about a paper that she wrote herself about fractures and child abuse, that's too aggressive. I'm sorry, but you are accusing these people of being evil monsters. So maybe it would be okay to let them defend themselves. Maybe it would be okay to let them ask the questions that any normal, healthy parent would do if they were actively concerned about the health of their child. So, the very first day of jury selection, May 12th, Governor Kemp signed a new law here in Georgia. It's called Ridge's Law. And it requires defect.
You can only argue the evidence, ma'am. If it's not in evidence, you cannot argue to the jury.
Argue Georgia law is in evidence.
Ma'am, if it's applicable to this case, meaning it was mentioned or going into during the trial of the case, not just that there's been some passage of a law. What prohibits you from going into that?
And this is why, again, I refer you to the Georgia Constitution of why you are the judges of the law and the facts. Because it's easy when you have a judge, and a prosecutor that have been working together for a long time in the same courtroom, it's easy to just assume that everybody who comes through these doors with an indictment is guilty. They must be a monster. This indictment was made against them. But that's why it's so critical for someone to do an investigation, ladies and gentlemen. And an investigation was done. A 2-year investigation was done. And everyone who participated in the observations of Matthew and Tuckey Hernandez and their children came here to testify on behalf of Matthew and Tuckey Hernandez. Again, you may disagree with some of the rulings about what was relevant. You may have wanted to hear more. But if there is ever a question in your mind at any point during the deliberation, that's a doubt, and you have to resolve it against the state. So you'll hear more in the jury charge about things like grave suspicion. You know, nobody can be convicted just because of the grave suspicion. You hear about excluding all reasonable theories of innocence. And what you would have to think happened here to agree with the state is that for 2 years, these people have somehow fooled every experienced CASA, daycare worker, DFCS investigator, foster parent, law enforcement officer, friend, family member, community member, all of those people who were given full access to everything about their lives, all of those people were somehow fooled and taken in. And only the prosecutor, who has thousands of other cases and constantly wants to argue that things aren't relevant, even when they have to do with the warrant for the arrest in this case, that they're somehow the only ones that got it right. But ladies and gentlemen, I think you know better than that. I think you know in your hearts what's the right thing to do, and I ask you to do it when you go back to the jury room. You'll elect a foreperson, you'll look at the evidence, you'll go back over your notes, you'll think about these 2 weeks, and you'll think about, as the conscience of Forsyth County, which you are, you know, I'm not even getting into the technical stuff, like venue. Of course the state hasn't proved that this happened in Forsyth County because they don't even know what happened.
Objection.
They don't even have an
Objection.
action.
It wasn't evidence.
You have argument. May I finish?
Maybe she can tell you in her second closing, when she gets the last word, where that evidence was of the it that they keep referring to. So keep your ears open for that, for sure. But all those technicalities, fundamentally, they don't always matter when it comes to a tiny child like Emma Hernandez. What matters is child safety. What matters is the best interest of this innocent child. And I put before you that the people who victimized her are not her parents, who love her and want nothing more than to continue being reunited with her and to help her grow and develop and play music and sing and go on camping trips and do all of the normal thing and go to bookstores and play with toys and play games and eat healthy food and learn about your cultures from your mom and your dad. They're amazing parents. They're wonderful parents. Emma Hernandez is incredibly lucky to have Matt and Tuckey Hernandez as her parents, because other people might have folded under what happened for the past 2 years. But they didn't. They are here standing strong, coming before you to make themselves available for whatever the state has to throw at them. And ladies and gentlemen, you've seen everything the state has to throw at them. A couple of lying doctors who can't even be bothered to follow her case throughout her multiple visits to the hospital. It's disappointing. It's shameful. But what it is that these people are not guilty of any of these charges against them. And I ask you to go back into that jury room and to make that decision for Emma Hernandez, for her family, and for any other family who has experienced this same nightmare of bringing their own child in for help and being turned into criminals and having their family torn apart. You have the power to fix this. You have the power to do justice, and I am asking, I'm begging you to do it. Thank you so much.
May it please the court, ladies and gentlemen of the jury, at least I'm getting a chance to talk. We know that jury service is difficult and disruptive in your lives. We believe that the truth in this case will come out through your verdict. Tuckey, Matt, Emma, and Aria, they've been waiting for this moment for almost 2 years. 2 years, almost 2 years. Tuckey and Matt are not guilty. They trusted the system. In order to have a crime, you have to have two things. You have to have mens rea, or the state of mind, and you also have to have the act itself. I submit to you, ladies and gentlemen, in this case, you don't have either one of those. The intent in this case is a malicious intent, which means a specific intent to cause harm. That's what's required. We haven't heard anything about maliciousness in this case. The act itself, you must have the coming together of the act and the intent to form a crime. We don't have a crime in this case. In fact, there is no evidence of motive. There's no evidence of intent in this case. The only evidence you've heard in this case is the good character of the defendants, their truthfulness, their nonviolence, their peacefulness, and their reputation. I touched upon the presumption of innocence during the jury selection and opening statement. The presumption of innocence is a real thing. The presumption of innocence is a brick wall that exists between the prosecution on one side and the defendants on the other side. The prosecution has to try and remove the bricks from that brick wall, and they have to prove the elements of these alleged crimes. There is no act, there is no malicious intent. They failed to remove the bricks. The wall of innocence still stands in this case. The burden of proof in this case rests upon the prosecution to prove its case beyond a reasonable doubt. You will receive jury instructions from His Honor about this. There's so much doubt in this case, so much doubt. We submit to you that the prosecution has not met its burden of proof. In my opening statement, I mentioned many things. I stated that this is a tragedy of epic proportion. You carry a child for 9 months, and suddenly and without warning, your baby is ripped away from you. I can't imagine. We understand the mandatory reporting aspect of this case. We understand that part. Many of our witnesses that we presented to you are mandatory reporters. What we don't understand in this case is the rushed diagnosis by Messner, along with the downplaying and the concealment of lab results that were far from normal. And, for that matter, the lack of a comprehensive genetic testing and follow-up labs. It's important to mention in this case that two of CHOA's own orthopedic doctors, Dr. O and Dr. Azakabu, orthopedics, they understood the diagnosis in this case to be vitamin D deficiency. And they recommended polyvisol supplementation, and they put Emma in a soft cast. Dr. Messner, he happily inserted himself into this case. Suddenly and without warning, and before all the results are in, Dr. Messner, he acts with orgasmic hypocrisy and makes a knee-jerk diagnosis of child abuse. That's what this case is about. The Hernandez family are a loving family. They took their daughter Emma to Sunshine Pediatrics and showed her because they were concerned for Emma and wanted answers. They put their trust in the system. They provided the information to the system. Matthew Hernandez took his cell phone and showed them the picture. This whole bruising situation. It's ridiculous. How many times did bruises in this case show up in the care of other people that weren't, and when the child wasn't even in the care of the parents? Numerous times. We spent a lot of time on the acrocyanosis situation. Why? Because it's important. Anyone can say that someone else caused that bruising. The orthopedics at CHOA, they knew what was happening in this case. The language that they use in the records is unremarkable. Some of the language in the records itself. This is from Dr. Nawakabu. Skeletal survey reviewed demonstrates irregularity. Irregularity. Not broken bones, irregularity of the proximal and distal femur, proximal tibia, and the first metatarsal. Concerning for healing fractures, but it's an irregularity. They weren't that concerned about it. This is from the orthopedic at CHOA. Again, from the orthopedic at CHOA. They can't recall any inciting trauma or accidents. Upon skeletal survey, irregularities of the right femur, tibia, and first metatarsal were found. Irregularities. Dr. Benson in this case told you that there are irregularities. They want it to be broken bones. We say it's irregularities. Their own doctors in the beginning of the case, when Emma was at the emergency room, say it's irregularities. The Hernandezes are a loving family. I think I mentioned that in my opening statement. They took their daughter Emma to Sunshine Pediatrics and CHOA because they were concerned and they wanted answers. That's all. They just wanted some answers. They cooperated, even showed a picture, as I stated before. We didn't want to go on and on with character witnesses in this case. I know character witnesses, it's boring. Jury duty is tough. It's boring. No one really wants to be here to do it, but we appreciate you for being here and paying attention throughout this entire case. Everyone was taking notes. Everyone was paying attention. We could see it. We could have brought in hundreds of people that can vouch for the credibility of the parents in this case. Hundreds, literally. But we wanted to be respectful of your time and make our deadline. Every character witness in this case testified that Tuckey and Matt are loving and caring parents of good moral character who can be trusted under oath, and their reputation is second to none. They would never hurt or harm their daughter Emma. You have been in jury duty for almost 2 weeks, but the defendants haven't had a normal family relationship for almost 2 years. 2 years. Their life was turned upside down when their 2 children were taken away from them. This trial has been an opportunity for them to tell you their story. You, ladies and gentlemen, in this case are the sole judge of credibility. We have heard some inconsistent testimony in this case, and frankly, quite baffling testimony from the prosecution witnesses in this case. And I would like to start with Dr. Messner. The evidence in this case shows that Choa ignored the abnormal test results. I think we hammered on that enough to show you guys that something's not right here. Choa ignored the abnormal lab results. The in-person examination and other signs and symptoms that baby Emma had been experienced were also ignored. Acrocyanosis, other issues, gut problems, vomiting, all that stuff. It came out through this trial. Dr. Messner testified that a high D-dimer does not mean anything and that it's only attributable to trauma. This is simply not true. Dr. Messner ignored the high fibrinogen levels. Dr. Messner ignored the low lipase level and the amylase levels that strongly contradict any claim of recent trauma. Throughout the medical records, it is mentioned numerous times that Emma's lab work was reassuring. We're not sure if the records want to go out with you that, but that's something that we'll discuss with His Honor. Dr. Messner told another doctor who wanted to do a blood clot study that Emma's lab work was within normal limits. Within normal limits. It's not true. It's so far from the truth, it's not even close. You are the judge of credibility. Dr. Messner testified that he was not even involved in the second Choa visit that Emma had. This is not true. Dr. Messner frankly ignored the acrocyanosis diagnosis, and he blew it off like it does not even matter. Dr. Messner inserted himself into this case as a child abuse editor. Dr. Messner did not issue a single in-house order in this case. In fact, all of Dr. Messner's orders that he did place were either discontinued or they were canceled. Did he have even authority to treat this patient? It's not really relevant as to why we're here, but did he? I think Nurse Amber Borders, when she testified, she read all this into the record. He did send a minimal request for a genetic test looking for a limited amount of information, I believe 2 genetic variants. These genetic variants showed up in Emma, several of them as a matter of fact. 2 of them were pathogenic. More importantly, Dr. Messner ignored Choa's very own orthopedic doctors, as I already talked about. Not a single orthopedic testified for the prosecution in this case. Not a single one. We're talking about bones. We're talking about alleged fractures, but not a single orthopedic from a big hospital, Choa, showed up at this trial. Not one. Not one orthopedic. That is telling. Dr. Messner ignored the vitamin D deficiency diagnosis made by his own orthopedic doctors, Dr. O and Dr. Nwakabu, who prescribed Emma with the vitamin D. Dr. Messner was wrong. He was wrong in this case. I'm not saying he's an awful person. I'm saying he's caught up in the system. Sometimes when people are caught up in the system, they become skewed, you know? Their bias and all that comes into play in these types of cases. Dr. Messner was biased. In my opening statement, I said, why? I just don't understand why. But I think during the course of this trial, we learned why. He's been in the system and he's designated a child abuse expert. He's caught up and he's biased. There are other things at play here, but they'll come out later. Dr. Chang stated a second D-dimer test was done during the July 23 visit and testified as to the result. This is another doctor, Dr. Chang from Choa. There was not even a second D-dimer test done in July of 2023. He was wrong. A D-dimer test was done at Georgia Hematology and requested by the family in 2024. Why? Because they want to know what's wrong. They love and they care about their daughter. over a year later, and it was still high. Dr. Chang tried to downplay the vitamin D deficiency and correct the high D dimer. He got caught. CHOA's very own guidelines, their very own guidelines that I used with the last witness that also testified here today. CHOA's very own guidelines show that Emma was considered deficient in vitamin D. Deficient. Also, they just blow off this acrocyanosis. You can have two types, normal or peripheral cyanosis, acrocyanosis. CHOA downplayed all of it. I'd just like to talk about the CHOA radiologist next just for a minute. I believe it's Dr. Mulholland Ray. She testified that the fractures on the leg, on the lower limb, were acute. Acute. None of these fractures, the ribs, anywhere on Emma, how you define them, were acute. Their own records say how they're all healing, old healing fractures. She comes in and testifies, oh, these are acute in June? Not even close. Again, you're the judge of credibility in this case. Dr. Messner calls an acute fracture, quote, one that shows no signs of healing. No signs of healing. The alleged fractures are healing in CHOA's own records. It's all over the records that these are healing. The alleged fractures are healing in CHOA's own records. Dr. Messner and Dr. Mulholland Ray are not on the same page. They're just not on the same page. I think to myself, am I missing something? CHOA has already designated these alleged lower leg fractures as old healing fractures. Something's wrong here. Dr. Mulholland Ray testifies that the ribs were at least 4 to 6 weeks old, at least. Images were taken in June of 2023, and Emma was born when she was born mid-March of 2023. And they all admit that it takes at least 90 days for the bone to remodel. 90 days. When you have a vitamin D deficiency, it takes the bone even longer to remodel than 90 days. More reasonable doubt. Their own doctor agreed that you can't date stamp these alleged fractures. You can only guesstimate. Ladies and gentlemen, I submit to you, we're not here to guesstimate. We got 2 wonderful parents on trial for felony child abuse and aggravated battery. We're not here to guesstimate. There's no guessing about it. Radiologists give impressions. Radiology is certainly not perfect. We've learned that through the course of this trial. Dr. Mulholland Ray gets into areas to try and deliberately bolster CHOA's case, but she's wrong because they're not acute. It seems like one doctor trying to cover and justify another doctor's claims and their actions. Dr. Ray testified about squeezing the child just like Dr. Messner did. The mechanism, that's another part, the mechanism of injury in this case is not even there either. It's speculation, pure speculation. In fact, children under 2 years of age with unexplained bruises will automatically get labeled as child abuse if you take your child to CHOA. It can happen to you, it can happen to your grandchildren.
Projection.
Dr. is an orthopedic surgeon, board certified by the American Academy of Orthopedic Surgeons since 1980. He didn't come in here because he was paid. He wants to help, like the hundreds of other people out here who also want to help. He's been in private practice as a general orthopedic surgeon and a spine surgery until December of 2000. Again, this case is not about money for Dr. And again, it's telling in this case how the only orthopedic is him. No bone doctors, no law enforcement. Because their own orthopedic doctors, based on the records, were only concerned about a vitamin D deficiency and prescribed polyvisol to baby Emma and diagnosed Emma with vitamin D deficiency. That was the final diagnosis in this case. It's on page 2 of the records. Page 2 is the final diagnosis. That's it right there, page 2. There is no diagnosis for child abuse, ladies and gentlemen. The diagnosis is a closed fracture. There is no diagnosis for child abuse. The final diagnosis, closed fracture and vitamin D deficiency unspecified. That's the final diagnosis in this case. That's why we're here. That's why 2 people have been charged with felony criminal charges in this case. Shame on them. They should have done more. Dr. studied the histology of various deficiencies. He's inherited metabolic bone disorders and all these fancy words that I can't even pronounce. Dr. has treated children with genetic bone-related problems, developmental failures, as well as bone infections and occasional tumors of the bone. He's highly qualified. He's a surgeon. He sees things from the inside out, not from the outside in. Dr. recognizes the effects of malnutrition on various deficiencies and their effect on the developing bones of children. CHOA does not. There are more than 100 known conditions which impair normal bone strength. More than 100. You heard Dr. testify that vitamin D deficiency can also start in utero or after birth. Their witness said, "Oh, there's no way. Vitamin D deficiency can't start in utero. That's not possible." Dr. testified about the demineralization of her teeth, and so did some other witnesses in this case, Tony Schultz and some other of the character and fact witnesses. I didn't even know they were going to say it. It came out naturally that her teeth are coming in crooked, they're demineralized. That was the people that were taking care of Emma, that cared about her enough and realized that something was just not wrong, something was not right with her, and that she was still experiencing health issues. There have been plenty of infants still hospitalized from birth who were discovered to have fractures while still in the hospital. Dr. Messner is significant to me. Dr. Messner in this case, he testified and looked me in the eye and said he ruled out everything in this case. It's not that he ruled out everything in this case, he ignored everything else in this case. He ignored it. I believe Dr. talked about the squeeze and how much pounds of pressure. I think he talked about 15,000 to 20,000 pounds of pressure that it would take to cause something like this. And that childbirth, something that being a man I never want to have to go through, and certainly feel that, 15,000 to 20,000 pounds of pressure. They try to make up excuses. Another excuse is this whole clavicle situation. Where's the pressure coming from? Is the pressure coming from the inside, or is it coming when the clavicle is almost out of the delivery canal? The pressure's on the inside. Tuckey was in labor for 12 hours. They just blow it off and say, well, she had no complications. Being in labor for 12 hours is not a complication. Again, Emma had gut problems. She had problems vomiting. She had infections. She had diarrhea. She had problems that were continuing. All the witnesses that had direct knowledge of this testified in this case as to those things that were going on. We get into the hormone. We get into the acrocyanosis, calcium and phosphorus and all that other stuff. There's other lab results that weren't right. It wasn't just about D-dimer. It wasn't about fibrinogen. It was about many other lab results that just weren't normal. The acrocyanosis was misunderstood. Was it really misunderstood, or was it just ignored? It can be confused with bruising, but it's not bruising. This condition continued to mysteriously exist, and it was written off by CHOA even when Emma was out of the care of Matt and Tuckey. You heard, I think it was interesting how one of the foster parents came in, nice guy, testified that, hey, when we gave her a bath, we took her out the bath and we noticed these weird marks and discolorations that appeared on her. But for CHOA, it doesn't matter. Don't take her to CHOA. Don't take her to CHOA. It appeared on the foot and legs with Tony and Tuck. It appeared on Emma with one of the foster parents, as I talked about, in the bath. It appeared a lot in the presence of daycare employees and the director who reported it. It appeared with the baby, with another foster parent, Tran Nguyen. They all reported it. Nothing was done. Nobody thought to pick up the phone from DFCS and give CHOA a call and say, hey, we got a problem here. The problem is they made the diagnosis too quick. That's the problem here. And once they made their diagnosis, they had to stick with it. They didn't want to go back on it. They can't be wrong. It's CHOA. All the evidence presented in this case about the cooperation and how the parents cared about the condition of their daughter came from the parents. Came from the parents. They tried to go through their head as a parent, your child gets taken away. What's the first thing you're going to start asking yourself? How did this happen? How did this happen? Where did it happen? What did I do? As a parent, as a grandparent, you start questioning yourself. It's normal. That's a normal thing. Allegations of child abuse were made and the children were removed. Mom was arrested. Several months later, Dad was arrested. Several months later. I'm not going to spend much more time on the labs. We all know that the labs were off and the labs weren't normal. They weren't reassuring. They stated so many times in those records that they do go out with you. You can look through it. It'll be in there. By the trauma department, reassuring. Labs are within normal limits. Another doctor wants to do a blood clotting test, and Dr. Messner tells him, don't worry about it, the labs are within normal limits. It's in the records too, page 527. 527, within normal limits. This is it right here. I'm getting old, but my memory's still not too bad. 527. Per Dr. Messner from last visit, all clotting studies return within normal limits. This is later down the road. Later down the road in July. Why? Because he couldn't change his mind. He doesn't want to change his mind. I'm sure ego plays a role in this as well, just like anything else. I'm sorry, but it's a mistake. You made a mistake, Dr. Messner. You had a chance to make this right before this trial even started. It didn't happen. A very low lipase level and low amylase level confirmed that Emma was not subject to any trauma at the time of her presentation for days prior. I'm not going to get in and recap all the witnesses. I wrote a lot down here, but my time is limited. And you know, during the course of this trial, my time has certainly been limited. All the questions were taken away before I even had a chance to get up. They didn't rule out other causes. They just didn't. Dr. Hutchinson testified. Dr. Hutchinson states no known trauma, no blood in the head or behind the eye, which would be indicative of trauma. Abnormal labs, vitamin D deficient equals high risk for fractures. cannot date the fractures, talks about the metaphysical lesions, last skeletal survey, everything is normal. Mechanisms have to be considered. No changes in the metatarsal. There's a long list of things here that can affect bone health. You can't rule out other diagnoses and issues when it comes to baby Emma. And the people that love and care about her are not going to stop trying to rule this out. I can promise you that. They're not going to stop. I'm just going to skip through some of this to save some time. Even the last witness, you know, she comes in, she's a radiologist as well, paid by CHOA, and she states that these are fractures. She's here to make and try and discredit Dr. That's the reason why she's here. I'll say this, when you make your decision in this case, weigh all the evidence in this case and think about the entire situation. I just ask you to please, please, please keep an open mind in this case. Keep an open mind. The unique situation with jury services is something else. Your decision in this case, once you make it, you can't take it back. As a juror in this case, once you make your decision, you can't take it back. You can always buy a car and sell it, change your mind, give it back. You can do these types of things. But where you're seated here today, you can't do that. Once you make your decision, that's your decision. The circumstantial evidence in this case doesn't even really exist. They talk about circumstantial evidence, and you'll get a jury instruction on circumstantial evidence, but it really isn't even a circumstantial evidence case, and here's why. Everyone's taught in law school that you have the footprints in the sand. The footprints in the sand go up to a house, the person walks up to the house, knocks on the door, and someone answers the door. In this case, no one is answering the door. No one's there. It's not even a circumstantial evidence case. It is nerve-wracking to represent innocent people. It really is. It's also emotional. We all have children, grandchildren, other people significant people in our lives. You have to think about the precedent that this case will set also in your decision. If you want your children, their children, future children.
Objection, Your Honor. It's inappropriate.
I'll withdraw it, Joe.
Thank you, sir.
After you weigh all the evidence in this case, you must find not guilty on all the counts based on lack of evidence presented in this case. And again, I thank you for your time and attention. I think we have a great panel of jurors here, and I believe you'll make the right decision and do the right thing. Up until now, it just hasn't been done. Thank you.
Thank you, Mr. Washington. All right.
Ladies and gentlemen, never have I ever seen two people who call themselves parents want and hope that their child is found sick as much as these defendants have here throughout the course of this trial. Every cough, every vomit, every ailment that a child can have throughout the course of their childhood was documented and mattered after the fact. Because they have to explain how their 3-month-old, who can't walk, who can't talk, who can't crawl, who can't roll over, had 8 fractures to her body. 8 fractures when Emma was never dropped and never fell off of anything. Defendants had no problem taking their child to urgent care for constipation, for vomiting, for nicking the nail, the skin when they were trimming the nail.
Objection, Your Honor. It wasn't defendants who took their child to urgent care for the nicking of the nails. It was defects because it happened during a supervised visitation.
All right.
But
Thank
you. But after they got caught, it mattered. What were they doing when Emma got bruises to her neck, her trunk, the diaper area from the car seat? What were they doing when she got bruising behind the ear? What were they doing when they saw that the child's scalp was swollen? What were they doing when they saw that one side of the child's face was swelling up? What were they doing when they saw that the child's leg was swollen? They didn't take her to urgent care. They waited. It only mattered when they realized that the doctors could see what they couldn't see, and they realized that. It only mattered when the doctors told them that they could see the history of what Emma's body had to endure. It mattered when they realized that none of the doctors, including Dr. Chanduri, Emma's pediatrician, weren't buying the story that Emma had a history of bruising from the car seat, bruising from holding her head while applying nasal spray, bruising from doing bicycles to pass gas and leaning in too hard. It mattered when they were facing criminal charges and were being watched. And now Emma, who up until this point had been healthy, growing, and thriving, according to Dr. Chanduri, who had seen her since birth, and now all of a sudden she's painted as this sickly child. It's not working. Throughout the course of this trial, we've heard a kitchen sink of defenses in hopes that one of these will stick. From rickets, vitamin C deficiency, vitamin D deficiency, copper deficiency, osteogenesis, imperfecta, the list just goes on. And I don't know what trial they were sitting in, but the state brought to you the people that you needed to hear from. No, we're not going to bring in an officer just to tell you, oh, we spoke to person A, B,
Sure, I'm
and
just
C.
going to go ahead and interpose an objection for purposes of the record that the state characterizing the defenses in this way is not accurate and not appropriate.
Okay, it's argument. You may proceed.
Thank you. No, we're not going to bring in an officer just to say, yes, we spoke to person A, B, and C, only to not be able to go into what A, B, and C said, because that's hearsay. We brought to you the people that they talked to so that you can hear for yourselves what they found and what they observed and what their findings were. We brought you the skeletal surveys. We brought you the medical records. We brought you the people that the defendant spoke to early on in the investigation in speaking with the defendants for their explanations of how these injuries happened. And no, we didn't call the pediatric orthopedic surgeon who put the splint on Emma because that was the extent of their involvement. They put a splint on Emma. Nurse boarders testified to that was the extent. But ladies and gentlemen, you can use your common sense. If the pediatric orthopedic surgeon didn't think there was anything wrong with Emma, they wouldn't have put a splint on her. Now, the defense has been painting Dr. Messner, the child abuse pediatrician, as this evil character who's on a mission to mark every child with child abuse. But ladies and gentlemen, let me remind you who all suspected child abuse even before we got to Dr. Messner. Emma's pediatrician, Dr. Chanduri, the ER doctor, Dr. Krieger, the social worker.
And Your Honor,
Dr.
again, she's
Rising.
mischaracterizing the evidence regarding these post-testimony. I recognize it's closing and that there is wide latitude, but when she is mischaracterizing testimony from the ER doctor that only came back after the skeletal survey, then I would object.
Okay, objection noted, objection overruled.
Thank you,
Continue,
Your Honor.
please.
Abby Rising, the social worker, the radiologist, I'm sorry, DFACS.
Your Honor, I'm sorry.
The radiologist.
Your Honor, I must object. At this point, is the argument from the state that the DFACS investigation is relevant and something that we can go into as evidence?
No, ma'am. No, ma'am.
Okay, I will make a continuing objection that we sought to introduce this evidence to the jury. and we're-
Ma'am, I've asked not to go into this in front of the jury. Thank you.
Thank you, Your Honor.
You may continue.
The radiologist, and then we get to Dr. Messner. All of those people, before it ever gets to Dr. Messner, suspected child abuse before Dr. Messner diagnosed Emma with non-accidental trauma. And then Dr. Wilcox, a geneticist, confirmed that he believes this is non-accidental trauma. Experts from within different departments all suspected child abuse, all say that this is child abuse. And yet the defendants would have you believe that this is genetics, that this is vitamin D deficiency. But ladies and gentlemen, if you recall the evidence was that her vitamin D level was low. but it was not so low that it affected her skeletal structure. It wasn't so low that it couldn't go up with multivitamins. It wasn't so low that it would cause fractures from normal handling. Now, the defense stating that vitamin D deficiency happened in utero, we heard testimony from Dr. Wilcox that babies take from their mother. So even if there was a vitamin D deficiency on the part of the mom, the baby's fine. It takes from the mom. If anything, it would affect the mom. And we heard testimony from the defendant herself that she fell during her pregnancy, and she was fine. There's nothing wrong with Emma's vitamin D other than the fact that it was just low. It did not affect her skeletal structure. So I want to go back. Also want to point out that vitamin D deficiency in and of itself does not cause people to spontaneously crack. Fractures are caused by some mechanism. It's a force great enough to break the bendy bone of a child. It's a force that cannot be generated by a 3-month-old who can't even roll over. It's a force greater than that which can be generated by a toddler, and that is malice. We'll talk about the labs. And even in Dr. own words, Emma was the most thoroughly tested infant that he's ever seen. And indeed, that is what the evidence showed. She had normal calcium levels. She had normal alkaline phosphatase levels. She had no blood clotting disorder. She had no blood disorder. She had no bone disorder. She had no kidney or liver disease. Everything turned out normal in her lab. She does not have a disorder. And we also talked extensively about the fractures because that is what they've been charged with. There was testimony that there were healing fractures, 3 rib fractures and 1 right foot fracture. There were also acute fractures, the 2 right femoral plasmataxial lesions, 1 right tibial plasmataxial lesion, and 1 left tibial plasmataxial lesion. And you heard testimony that rib fractures and plasmataxial lesions are highly specific for child abuse. This is not from the normal handling of a child. The fact that there were healing and acute fractures show that these happened at different points in time. The child was fractured not once, but on at least 2 different occasions. And I also want to point out that Dr. in his testimony denied there ever being any sort of plasmataxial lesions. I do think it's curious that defense fails to bring up the testimony of Dr. Krishnamurti and Dr. Hutchison. Dr. Hutchison, their own pediatric radiologist, admitted that she too saw rib fractures. She too saw at least 1 plasmataxial lesion. Again, it's up to you to determine the credibility of these witnesses. Bruises. Bruises were brought up several times throughout the course of this trial, and the main purpose of it was to explain for why there were additional skeletal surveys done. Emma didn't have 4 skeletal surveys just because of this one incident. She went up on June 6th. She went in for the skeletal survey. As a follow-up, she went again in June, and then in July there was a new incident happen. That's why Emma has more skeletal surveys than would normally occur on a child for 1 incident, because there was more than 1 incident that happened in this case. And what you heard during trial was that you could see from the skeletal surveys that there was further evidence of healing of the prior fractures, but there were no additional fractures once Emma was removed from the defendants. There was also no additional bruises once Emma was removed from family members. And we know that because despite the fact that the daycare center witness said that she saw bruising on the soles of the feet, she leaves out the photo of the squeeze marks. She denies that she saw those when she saw Emma. She only identifies the photographs of the bottoms of the feet. She does not acknowledge the squeeze mark photographs. We also heard testimony from one of the defense's witnesses that they took photos of bruisings that she saw, but she never gave them to the defense. And we don't see them here today either. And ladies and gentlemen, defense has brought up acrocyanosis multiple times. And I think you can also use your common sense. Anyone who's had a child knows what acrocyanosis looks like. But we've also heard testimony on what acrocyanosis is. We've heard testimony from one of the foster parents, Mr. Irvin, of what acrocyanosis looks like. It's when the child has a temperature change, can't adjust, looks blue, and that warms up very quickly. It does not last for days like bruises does. We've also heard a lot about genetics. Her POL1A1 was tested, there was no abnormality. POL1A2, there was no abnormality. We heard from Dr. Wilcox that there was no disorder predisposing her to fractures. There was no evidence for rickets. There was no evidence for vessel myopathy. There was no evidence for hypermobile Ehlers-Danlos. She doesn't have cystic fibrosis. And we heard a lot about variants, genetic variants. But again, it's been stated by both Dr. Wilcox and their own geneticist. Just because you have a variant does not mean the child has a genetic disorder. It has to manifest, it has to present, it has to show. And this child, Emma, did not have any of that. Now, Dr. Krishnamurthy said decades down the line she may, but she didn't have it on June 6th or prior to that point. The child does not have a genetic disorder. And again, credibility is for you to decide. Now, they attacked the CHOA doctors, they've attacked DFCS workers. Ladies and gentlemen, CHOA doesn't go knocking on doors trying to take people's babies away. They have a duty. They have a job to do. They are mandated reporters. In a sense, it's no different than if a teacher were to see bruises on a child and they report to DFCS because they are mandated reporters. For these doctors, they can read skeletal surveys and they see what is equivalent to a layperson seeing something on the outside. They saw signs of child abuse. That is why they reported it. What motive do they have to make this up? To have this vendetta against this family? They're just doing their job. And they came here and testified because they received a subpoena to do so. And the same is true with DFCS. They weren't.
Your Honor, I would object to any mention of the DFCS investigation since it has, of course, been ruled irrelevant.
Are you addressing testimony presented by DFCS?
Talking about testimony that was presented by the workers.
Right, okay, I'm allowed, go ahead.
And Your Honor, I would make a continuing objection because we were not allowed to present testimony from DFCS workers.
She'll only be allowed to argue and comment on the testimony that was here in the courtroom.
Just want to make sure the record is complete, Your Honor.
Yes, ma'am. Thank you.
And the same is true with DFCS. They didn't just randomly take these people's children away. They heard the reports of the doctors. They spoke to the defendants. Something didn't match. In order to protect the child was removed from the home. And the defendants testified. Ladies and gentlemen, the defendants have every reason to lie. They are the ones sitting in trial. They are the ones that are facing these charges. So whether or not you believe what they say is up to you. But I would say that that is something that you can consider when judging their credibility. The same applies to their friends. Now, there's been a lot of testimony about their good character, but ladies and gentlemen, people usually don't abuse their child in front of other people. There's a reason why these cases are hard. It's because it happens behind closed doors. And especially when it happens to a child who can't talk, that is when we do have to rely on the medical evidence. Because what other way is there to protect this child? Defense's experts, and again, I do think it's curious that they left out Dr. Krishnamurthy and Dr. Hutchison. Dr. Krishnamurthy, she was a very sweet lady. She couldn't testify to a whole lot other than that she was very curious about a lot of these genetic variants. A lot was unknown, but she admitted that nothing was presenting in Emma. And really, between all of defense's experts, she was the only person that's actually had contact with Emma, that's actually laid eyes on Emma. And she did not see any genetic disorders present on Emma at the time. Dr. Hutchison. Dr. Hutchison, who is a pediatric radiologist, who's had a lot of experience working at children's hospitals and currently works in private practice, who was essentially a hired expert, even she could not say that these fractures weren't there. She can see the fractures. She can see the rib fractures. She can see the classic metaphyseal lesion. There were fractures on Emma. And she also testified that there was absolutely no evidence that Emma had rickets. There was no evidence that there was anything wrong with her bone density. All she could say was vitamin D can affect bone health. But there's no evidence that it did. And for Dr. Benson, I would like to point out that he seems to contradict all the doctors, really. And if you recall his testimony, he was tendered as an expert in a very specific area, and yet he seemed to have a wide gamut of knowledge in all these other things. He was suddenly knowledgeable in OBGYN, he was knowledgeable in dentistry, he was knowledgeable in genetics, he just knows everything. And ladies and gentlemen, I would ask that you compare what his testimony was with even the defense's own experts. Ladies and gentlemen, defense wants you to feel bad for this couple. They have attempted to use sympathy.
The court will, of course, instruct them that sympathy is not a favor, and so
Yes,
the
ma'am.
process of seeking that as well.
I will give that instruction.
Thank you, Your Honor.
They have attempted to use sympathy to get you to forget what the actual facts in this case are. They've tried to distract you with completely, utterly irrelevant evidence. But ladies and gentlemen, these defendants both played a role in this. They were both the only two caretakers for Emma. They were the only individuals with sole access to Emma in their home in Forsyth County when her bones were broken. And her bones were in different stages of healing, meaning that it happened more than once. And ladies and gentlemen, I submit to you that the defendants presenting photo of the ear bruising and listing possibilities of what they think happened, it wasn't being cooperative or forthcoming. They knew what happened to Emma. They probably got scared that what happened to her this time was a little too much, and they took her to the doctor. And then they came up with excuses to cover their tracks. And when the doctors and DFCS didn't find the excuses plausible, they came up with more. And that's what they tried to do throughout the course of this trial, in hopes that something will stick. Ladies and gentlemen, it's not a coincidence that after the child was removed from the defendants, the child no longer had fractures. Sometimes the simplest explanation is usually the correct one. And in this case, it's because this is child abuse. This was aggravated battery, family violence. This was cruelty to children in the first degree. They were the only two caretakers, the only individuals with access to this child when her bones were broken. That is child abuse. Abuse of the most innocent of all human beings. A child who can't talk, who can't roll over. Dr. Chanduri did her duty. Dr. Krieger did her duty. Dr. Mulholland Ray did her duty. Dr. Lyman did her duty. Abby Rising, the social worker, did her duty. DFCS did their duty. Dr. Mesner did his duty. Dr. Chang did his duty. Dr. Wilcox did his duty. Everyone did their part to protect them. And now it's your turn. I ask that you find defendants guilty of all charges.
Thank you, Chief. All right, counsel, I have a copy of the charges that will go out, which you're welcome to look at. I've got the verdict form. I understand everybody's looked at that, but you're welcome to look at that again. I got a copy of the indictment with the witnesses that have been redacted. So that's not part of it. So that will go out with the jury. Do we have the evidence that will go out with the jury? And I'll address any objections or any concerns that you have with that. I would just ask that counsel look at all the evidence before it goes out. I'll remain on the bench, look at it, and make sure everybody's in agreement what goes out. And if there's some objection to something that's in the record going out, again, I'm staying on the bench to address that, okay? So.
Thank you, Your Honor. And I would ask if we can review the copy of the grand jury indictment and redact the names of the grand jurors.
State have any objection to that?
I mean, this is not the indictment. I don't understand what significance is.
Let me do this. I've never had that requested. I don't have any problem with it then. I mean, I can redact that.
Thank you very much, Your Honor.
I will put juror name removed.
Thank you very much, Your Honor.
Okay, I can do that. So counsel, I'm going to step off the bench to go do that. When I come back, if we could address the other, okay?
Yes, sir.
All right, thank you. Well, I think medical reports do not go out if the witness testified.
That's fine, Your Honor. I just don't think defense reports go back after the
No reports go out. Medical records. Talking about records go out, reports don't go out.
I think that's the issue they're having. What defense is, or sorry, state 6, it is a medical record. They're saying that it is a report. It's part of a medical record. But if this is an issue, I don't have an objection to just leaving the medical records here and not back with the jury. The medical records have the doctor's notes during the course of their order, so I don't. It's different from defense.
The way I'm looking at this, some type of conclusionary report, and the doctors testified. That's the purpose of the continuing witness rule, so it's not going back and repeat it, if you will. So medical records can go out, but medical reports do not.
Well, the
And I'm
problem
not
is
looking at all this up.
Your Honor, what they testified to during the trial is basically the same narrative that's also in the medical reports too. So that's the problem that we have, is it's basically not just a medical record, but it is a narrative of the person that's already also been classified as the expert. There's duplicity, I guess, is what I'm getting at, Judge. So that's what I want.
Well, I'm not looking at what you're looking at, but, continuing witness rule, in my perspective, is that if there's a medical expert who are making conclusionary statements, which are, which they've testified here to, they don't go back. Now, I don't know if they've been I don't know what part of the record they are. Can you remove them, or?
It's all over the record.
It's embedded in the medical. That's what I'm saying. That
Can you work out something and agree to something?
I don't think there is any way to extract the state's experts from the medical records, Your Honor.
Ms. Sheet?
I think it just needs to stay here and not back with the jury. can't extract it.
Well, they've been admitted into evidence. There's not a legal reason to exclude them.
Well, I mean,
So
our
that's why,
position,
other than if there's a report. So what else want to do? The jury wants to deliberate.
I'm
I'm
fine.
waiting for 9 days.
There's so much in there. There's stuff in there too, Judge. I mean, it's loaded. They're loaded enough. It'd be impossible to extract it without, I mean, it'd be impossible. I mean, it would take weeks and weeks. Do it in my opinion.
Well, that's why I'm asking if there's some form of agreement that you can reach. Stipulation.
I mean, that's what I'm, that it, since it's, the doctor's diagnosis, impressions, all of that is embedded inside the whole medical record.
And they were experts as well. So I think our solution is just to leave it all out. I'm in agreement with Ms. Yee on that.
Just leave it all out.
Except for the photos and some of the other stuff.
Mr. Bernard, will you concur with that?
yes, I will go along with that, Your Honor.
Okay. So let me ask this, with that understanding and that stipulation, have you looked at any other evidence? Are you in agreement with that, what goes out?
I believe so, Your Honor.
We don't have to identify it by exhibit, but if there's one exhibit that you don't agree, that's what I want to know.
You're chatting more like that.
I'm sorry, there was something that popped up. We do want all of the photographs in. Your Honor, there is one Defense Exhibit 19 that we believed had been tendered and admitted in a review of the record. It was presented. I'm not sure that it was formally tendered and admitted.
What is the exhibit?
It's the photograph of the first day at the hospital with RES and Emma, Your Honor.
It was certainly testified to, Judge, during one of the witnesses on the stand.
It was.
Does she have any objection?
I mean, if it wasn't tendered, it wasn't tendered.
Your Honor, it was presented with a number and
Was it testified to?
it was, Your Honor.
If it's testified to, I'm going to allow it because basically by allowing the testimony to be taken from that document, I think there's a waiver. Okay?
Thank you.
So that will go in. Okay?
Yes, Your Honor.
All right, so is there a representation by all counsel that you've reviewed the evidence, you're in agreement with the evidence, and that evidence can go out with the jury at this time?
Yes, Your Honor. We'll just check so all of the medical records and expert reports will not go out.
Well, do me a favor, I think there's a better practice. Put what you're going to go to the jury in a separate stat pile, whatever you want to call it, and take the other and put it in another one, so it's not commingled or confused.
I think we're ready to go, Your Honor.
Mr. Gard, you agree what's going out with the jury?
I do, Your Honor.
Okay. Mr. Washley, you agree?
Yes, Your Honor.
Ms. Shee, you agree? Ms. Shee, I need an affirmative response, yes or no? You agree with what they decided to go to the jury? Okay, all right. That issue's now been addressed. Anything else we need to address, counsel?
No, Your Honor.
All right. Ladies and gentlemen, we're going to stand at ease until we receive a question or a verdict. Thank you. Counsel, I've received 2 questions from our jury. I'll mark each one separately, beginning Court's Exhibit 1. And then the second question, Court's Exhibit 2. All right. First question. It's dated, and I don't know the initial. I don't have my juror list. Maybe
Mr. Mays, sir.
Mr. Mays, at the 4-person.
Yes.
All right. Here's the question: why are medical records being withheld from deliberation? Second question: can we ask for specific medical records or data? So, How's council want to respond to this or address it?
I think the continuing witness rule, Your Honor, and just some construction to that extent under these circumstances, because the medical records did contain a lot of narrative information from experts that already testified on stand. It's basically the continuing witness rule. I think I would be okay with something along those lines and see what they come back with that.
Your Honor, because I did find case law, and this is Hudson v. Lawson, 227 Georgia, Court of Appeals 490, it's a 1997 case.
Can you say the site again?
Yes, Your Honor, 227 Georgia Act 490, 1997 case.
Yeah.
There, the trial court found that there was no error in sending the medical records out with the jury.
Well, what's the definition of medical record?
So the defendant claimed that the trial court erred by admitting to evidence and allowing into the jury room medical records identified by the treating physician who testified at trial. He claimed that this violated continuing witness rule because the record substituted as a written record of oral testimony. The medical records at issue were identified by the treating physician and admitted as original evidence. The records were not read to the jury and were not written testimony, merely duplicating the physician's testimony or substituting as a written record of the testimony. And they found that there was no error in sending the medical records out with the jury.
And Your Honor, it does appear to be a civil case. I'm looking through it, so I don't think it's necessarily going to be able to help us here.
I say there was another case where Patarazzi State, that's 358 Georgia Court of Appeals 675, and that's a 2021 case.
Is that a criminal case?
It is a criminal case, and they cite to the civil case where the continuing witness rule was not violated by allowing the plaintiff's medical records to go out with the jury.
All right. Any other thoughts?
I would concur that a response on question 1 about the continuing witness rule would be appropriate. And I would say as to can we ask for specific records? Yes, they can ask for specific records, and the court will determine if they are subject to the continuing witness rule.
All right. Your position is that
In reviewing the case law, I don't think the medical records are considered original evidence. It does not violate the continuing witness rule. The records are also not created for the purpose of trial here. It's not testimonial in nature. So I do believe that it does go back to the jurors, and the jurors can, I guess, make of it what they will. I will say that is different from the defense expert reports because those were specifically written for the purpose of trial. So that will be a continuous violation.
well, I'm going to step off the bench and look at these two cases and come back with my decision, okay?
If I could make one more note that I think will be a factor, as of course the court is aware, there has been a lot of going back and forth over which set of records, whether it's the set that was certified to the juvenile court, or the set that was certified to the sheriff's office, or the set that was certified to the district attorney's office. These records have been modified extensively even after they have been sent. So in terms of the state's assessment that they were not made for the purpose of trial, I don't believe that that is supported by the evidence, and that much of what these doctors have placed in there has been related to trial and prosecution.
These are the doctor's narratives are part of their treating at the time that they were doing the treating or their follow-up. As far as which reports would go in, I'll just say the ones that were presented to the court and represented the court and provided here and marked as exhibit, I think 1 and 2. Is that correct? That's the version we're going with, is what I'm saying. Okay?
I would say that the jury's second question indicates that if they have specific records, then they could request those and the court could make an appropriate determination.
Okay, thank you.
Thank you, Dr.
Thank you.
And Your Honor, the issue we're having is my continuing objection from the trial regarding the presence of information in these records that we sought to bring before the jury, but it was ruled irrelevant. And so at this point, there is information that is going to go back to them, that we had additional witnesses that we could have called and questions that we could have asked to those witnesses that would have illuminated the information that is in these records. But now it's going to go back to the jury even after you found that those items were irrelevant. So that is what we are going to do.
They're irrelevant to this criminal prosecution. What can we remove those? Or
I don't know what they're talking about.
well, everybody's standing here. Can you not talk with one another, please? Show what Ms. Bernard, show Ms. Hugh what you're talking about, so we can address
I
it.
mean, I will show you one example of the law enforcement. You know, there's discussions of interviews with law enforcement. We're not able to go into. So, like, for example, would be one of the social work clinic notes from June 23rd of 2023.
This is a social worker at the hospital?
Yes.
Okay, I'm allowing that. That's at the hospital.
Okay. Well, I mean, these were questions that our witnesses had information about that we were prohibited from going into.
Yes, ma'am. I'm doing what the doctor had, what these doctors had.
Well, and again, if we had been allowed to go into this during the trial, then we would not have an objection to this. So that's the concern that we have right now. Is
I understand.
Yeah.
I understand. All right, let's assemble. They're going out with a jury. I want to let them know that I have met with. Thank you.
All right, and so we'll just go ahead and put on the record that we have not been able to complete going through page by page, subject to the court's new ruling on this.
Yes, ma'am, and the court also notes for the record that there's a stipulation as to these being admitted. Counsel had plenty of time to know what's in the record. All right, let's, I got a third question for everyone from our jury. I think it's much easier, less controversial. Can we use a flip chart? Anybody have an objection to a flip chart?
No objection. No objection whatsoever.
Okay, all right, very well. All right, let's bring our jury back, okay? All right, thank you. Ladies and gentlemen, please be seated. All right, ladies and gentlemen, I've received 3 questions. The first one is why are medical records being withheld from deliberation? Second, can we ask for specific medical records or data? Third, can we use a flip chart? The court this time is going to allow certain medical records back to the jury. I've made a determination of what can be to go back to the jury deliberation for your consideration and what is legally not entitled to go back. Going to your second question, if there's something in that you don't see that you thought you'd be receiving, you can specifically ask for it, and we can see if for some reason it can go back. I'm happy to do that, but these are the records that I'm allowing to go back, okay? Just so you know. As to the third question, which I think is probably easier, answer is yes, you can use a flipboard, okay? All right? All right, you can continue at this time back, and these will be brought back to you, okay? Thank you. All right, other than the previous objection, anything else on that issue?
Judge, I don't put enough cash on the record. The medical records going back. I believe a lot of the information in the medical records is testimony. I believe all the experts testified to a lot of the information in the medical records. I think it's a violation of continuing witness rule. I think it's a violation of hearsay because it's loaded with hearsay. And I just wanted to preserve my objection for the record. I believe we also stipulated initially that the medical records were not going to go back between counsel and just in the record.
All right, Okay, anything else? Anybody
Yes,
else?
and to be clear about the nature of my objection, it is that during the state's case, the court had not yet made the ruling that the DFACS investigation was irrelevant and that the conduct of juvenile court was irrelevant. And so the state was permitted to present witnesses on those subjects. However, when the defense sought to call witnesses on the same subject, it was then ruled that that information was irrelevant. Therefore, there is information in the medical records that my clients have no fear of going to the jury whatsoever because it doesn't change anything about their innocence. However, their counsel has been deprived of the opportunity to bring the witnesses before the court and ask the questions that would allow the information in those medical records to be fully digested and understood by the jury.
All right, thank you very much. Anything
I'm
from the
doing
staff?
that as well, so on behalf of Mrs. Hernandez.
All right, Mr. Vice, anything from the staff? All right, thank you.